On sexual harassment in the workplace. How did the POSH Act come into being? How does it define sexual harassment and the workplace? What does it require employers to do? What are the serious lapses flagged by the Supreme Court? What have been the hurdles to the law's implementation? The name of the explainer is Diksha Munjal. The story so far. 10 years after the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, POSH, came into force, the Supreme Court Bench of India has said there are serial lapses and uncertainty regarding its implementation. How was the POSH Act formed? In 1992, Bhavri Devi, a social worker with the Women's Development Project of the Rajasthan government, was gang raped by 5 men after she tried to prevent the marriage of a 1-year-old girl. While hearing pleas filed by activist groups against the crime, the SC, noting the absence of any law enacted to provide for effective enforcement of the basic human right of gender equality, guarantee against sexual harassment at workplaces, laid down a set of guidelines in 1997, christened the Vishakha Guidelines, to fill the statutory vacuum till a law could be enacted. These were to be strictly observed in all workplaces and were binding and enforceable in law. After this, the Protection of Women Against Sexual Harassment at Workplace Bill was introduced by then Women and Child Development Minister Krishna Tirath in 2007. It was later tabled in Parliament and went through amendments. The amendment bill came into force on December 9, 2013 as the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal or POSH Act. What is the POSH Act? The POSH Act defines sexual harassment to include unwelcome acts such as physical contact and sexual advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, and any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. Under the Act, an employee is defined not just in accordance with the company law. All women employees, whether employed regularly, temporarily, contractually, on an ad hoc or daily wage basis, as apprentices or interns, or even employed without the knowledge of the principal employer, can seek redressal to sexual harassment in the workplace. The law expands the definition of workplace beyond traditional offices to include all kinds of organizations across sectors, even non-traditional workplaces. It applies to all public and private sector organizations throughout India. What are the requirements imposed on employers? The law requires any employer with more than 10 employees to form an Internal Complaints Committee (ICC), which can be approached by any woman employee to file a formal sexual harassment complaint. It has to be headed by a woman, have at least 2 women employees, another employee, and a third party such as an NGO worker with 5 years of experience familiar with the challenges of sexual harassment. Besides, the Act mandates every district in the country to create a local committee to receive complaints from women working in firms with less than 10 employees and from the informal sector, including domestic workers, home-based workers, voluntary government social workers, and so on. The employer has to file an annual audit report with the district officer about the number of sexual harassment complaints filed and actions taken at the end of the year. What are the hurdles to the Act's implementation? The Supreme Court, in its recent judgment, called out the lacunae in the constitution of ICCs, citing a newspaper report that 16 out of the 30 national sports federations in the country had not constituted an ICC to date. The judgment also flagged the improper constitution in cases where the ICCs were established, pointing out that they either had an inadequate number of members or lacked a mandatory external member. This, however, is not the only implementation-related concern when it comes to the POSH Act. One of the concerns of the Act is that it does not satisfactorily address accountability, not specifying who is in charge of ensuring that workplaces comply with the Act and who can be held responsible if its provisions are not followed. Stakeholders also point out how the law is largely inaccessible to women workers in the informal sector. Additionally, experts have noted that in workplaces, sexual harassment cases are hugely underreported for a number of reasons. The framers of the law had recognized that complaints could be more effectively addressed within civil institutions or workplaces so that women did not have to go through the daunting process of the criminal justice system related to accessibility and timeliness. However, the inefficient functioning and the lack of clarity in the law about how to conduct such inquiries have ended up duplicating the access barriers associated with the justice system. Most importantly, the power dynamics of organizations and fear of professional repercussions also stand in the way of women for filing complaints. What are the Supreme Court's recent directions? The court directed the union states and union territories to undertake a time bound exercise to verify whether ministries, departments, government organizations, authorities, public sector undertakings, institutions, bodies, etc., had constituted internal complaints committees ICCs, local committees LCs, and internal committees ICs under the Act. These bodies have been ordered to publish the details of their respective committees in their websites.